Okay, so we're going to be talking about Rule 403 right now. Specifically, we're going to be talking about narrative. It's not one of the rules listed explicitly under 403, but it's colloquially known from one of these rules. So we'll take a look. Rule 403 says excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. So even if evidence is relevant, it can be excluded for one of these reasons that are closely tied to relevance, but aren't relevance explicitly. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following. We're going to be focusing on one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Essentially, what this rule is saying is that if evidence has so little probative value, like it's relevant but just barely, and it has any of these other issues, then it can still be excluded under this rule. The one we're talking about today is narrative. Narrative objections come from are rooted in the misleading or the undue delay and the wasting time portions of Rule 403. Colloquially known as narrative, when you object to it, use narrative. The way you would object is to say, Your Honor, objection, Your Honor, this question calls for narrative and is inadmissible under Rule 403. Or if you're objecting to the witness's answer, objection, Your Honor, narrative, the witness has been going on and it hasn't been adding anything to the trial. So it's inadmissible under 403. The premise here is simple, that there is a very real concern that trials last too long and that judges need to get their work done. And if people just go on rambling for hours and hours, then it could affect the functioning of the legal system. The problem is that it's really, really hard to win narrative objections. It takes something very egregious to qualify as an undue waste of time. Because if it's Andy Park going into a narrative about like her life, you can see how that's relevant. You could see how it's a perfectly reasonable thing to come out in trial. But so essentially the standard is very high it has to be very egregious to get excluded as narrative or of any of the rules under 403 in particular. I would avoid making narrative objections, but you're going to have to respond to narrative objections. In responding to them, there's two ways you can really go about it. You can respond to narrative by saying, well, no, this is probative because of blah, 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 blah. Like this is useful stuff. But even if you do that, the judge is probably going to ask you to do what I think you should do regardless, which is just stop the witness, apologize that like you did ask a specific enough question, and then ask a more specific version of the question you had asked before. I don't think that given our directing style, this is something that we should ever have to argue against. We ask very pointed, or we strive to ask very pointed and directed questions that would not elicit narrative responses, almost yes or no's, without it being literally restricted to yes or no. That's what we should be aiming for when writing our directs. But there are questions, especially with emotional witnesses, of which there are tons in Park v. Duran, where you ask questions like, well, why are we here today? Could you tell us a little bit about your family? Those questions call for narrative. They're very broad, overly vague, and one, they're not the best questions, because if a witness gives you exactly what you want to a question like that, it comes off as scripted. That's one problem. But two, because they're so overly vague, and before the witness answers, you don't know how they could. I mean, tell me about your family. Do you want me to tell you how my great grandparents came over from Ellis Island, in the 1700s or some shit? It's very vague. It's very broad. And you can get objections before the witness even begins to answer. Has the question could call for narrative. Be aware of that. Be able to respond to it. If you get the objection, it's not one I would choose to fight. You're not going to prove your legal chops by arguing the probative value of this narrative rambling answer from this character or this crier. The better way to do it is say, yes, Your Honor, I withdraw my question. I'll rephrase. Now, and then once you withdraw the question and rephrase, instruct the witness. Now, Ms. Park, I know that it's been hard for you. I know that you miss Sydney dearly, but I'm going to need you to answer the questions sticking very closely to the events of August 18th. Something like that. That wasn't the very great example, but that's narrative. That's how you would object to it. That's how you would respond to it. And Rule 403 is the rule that it is included in. Next, we'll be talking about cumulative, and then we'll talk about prejudicial versus probative lastly, as it relates to the same exact rule, Rule 403. Thanks for watching.